Justices appeared divided on Wednesday while hearing arguments about whether Idaho should be forced to allow abortion during medical emergencies. Congressional correspondent Stephanie Liebergen has the latest.
Idaho is already facing another lawsuit from women and medical professionals who say they have been harmed by the state law. The Supreme Court's decision in this case would have major implications on what constitutes emergency care in states with abortion bans. Abortion is back before the Supreme Court, with justices debating whether Idaho's near total abortion ban overrides federally mandated requirements for emergency care. Idaho instituted one of the country's most restrictive abortion bans after the Supreme Court overturned Roe v. Wade in 2022, making it a felony for a doctor to perform an abortion except to save a patient's life. The Biden administration argued the federal emergency medical care law known as EMTALA supersedes Idaho's abortion ban. EMTALA requires Medicare participating hospitals to provide stabilizing emergency treatment to prevent a patient's health from getting worse. The federal government argues this leaves doctors unable to treat pregnant patients with serious complications.
If a woman comes to an emergency room facing a grave threat to her health, but she isn't yet facing death, doctors either have to delay treatment and allow her condition to materially deteriorate, or they're airlifting her out of the state so she can get the emergency care that she needs.
But Idaho's attorney argues EMTALA doesn't conflict because the law only requires hospitals to perform available treatments, and most abortions are unavailable in Idaho. They also say Idaho's law still allows life-saving procedures for complications like ectopic pregnancies, but not necessarily treatment to preserve a woman's health.
Potential loss of an organ or serious medical complications for the woman, they can't perform those abortions.
If that condition exists, yes, Idaho law does say that abortions in that case aren't allowed.
Stephanie Liebergen, Scripps News, Washington.
And joining us now to discuss this issue further is Azalea Carlia, Legal Director at Legal Momentum. Thank you so much for being here. So the Supreme Court heard arguments from both sides, expected to rule in June. I want to get your take because the justices were really divided here. And something that struck me that was very interesting was Amy Coney Barrett, who's known for being very on the right. She actually said to the attorney in Idaho that, you know, when he said things would be decided on a case-by-case basis, woman per woman, with this law, she said, I'm kind of shocked. I thought your own expert had said, you know, some cases were covered. She's saying, you know, the lawyer's saying you're not. So she really kind of had some hesitations here. With what we heard, where do you think the court may be leaning here?
Well, first I want to say good morning. Thank you for having me with Legal Momentum, the nation's largest, oldest women's rights organization. And we were appalled at what we were hearing yesterday. You know, we saw, you know, a huge divide among the justices, among ideological lines. And, you know, we think that lives are at stake here, not just women's lives, but potentially any patient that presents you know, in front to an emergency department seeking emergency care. You know, the law is clear, the federal law is clear that any Medicare funded hospital across this country must provide stabilizing treatment to patients. And in the case of Idaho, which is saying that it can carve out exceptions for pregnant patients, you know, we feel that that is appalling and frankly will endanger the health and lives of a lot of patients across our country. And yes, you know, the fact that it was Justice Barrett who seemed shocked, you know, should give everyone pause to realize that this is potentially devastating for lots of patients across this country.
So at the heart of this argument is the Emergency Medical Treatment in Labor Act. So for some of our viewers out there who may not know exactly what that is meant to do, what is it there for?
It's there, it's been there for 4 decades, and it says that if a patient presents at an emergency department of a hospital with an emergency medical condition, they must be treated. So they have to, the hospital has to provide that emergency care in order to stabilize the patient and ensure that there is no material deterioration in that patient's condition. And this law was put into place under the Reagan administration in order to ensure that patients who were poor, couldn't afford to pay, were underinsured, didn't have insurance, they could receive that emergency care to stabilize their treatment. And so, you know, for the court to say that they're unsure of whether this this law should be upheld is really terrifying, and it should concern all Americans across this country, because essentially it would mean that states could pick and choose which stabilizing care they want to give to patients, and that is just, you know, a scenario that we don't want to envision.
And if someone
it would have devastating consequences for patients.
And if someone is going to the emergency room, it's typically an emergency. So do doctors have time to even go through all of this and think about this type of law and what it could mean? Because doctors are now facing up to 5 years in prison if they violate Idaho's law. It doesn't seem like an emergency situation should be taking up this much time.
Exactly, and that is what the federal government, that is what the Biden administration is arguing, that you're really taking away the discretion of doctors and medical providers to act in the best interest of their patients, to make those medical decisions. And especially in the case of pregnant patients that would need an emergency abortion or termination of their pregnancy, you know, doctors have said, medical providers have said, you know, what is that decision going to look like? Like, we're going to have to wait until she's hemorrhaging, she's bleeding out, like she's going into septic shock, she's having a seizure, she's having a stroke. At what point can doctors actually intervene to provide that stabilizing treatment and that care that, you know, made the patient present to the emergency department in the first place? It would be, you know, a very drastic intervention in that patient-doctor relationship.
Yeah, certainly a ruling that we will be keeping our eyes on. Azalea Carlia, legal director at Legal Momentum, thank you so much for your time.